Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam. I'm Jeny Maier, and today's episode is it fair? The FTC's policies and enforcement actions on unfair methods of competition under Section 5. I am here with my co-host, Sergei Zaslavsky. Hi, Sergei.
Hi, Jeny.
Can you introduce today's guest?
Sure. Dan Graulich is a lawyer with the Baker McKenzie firm. He does antitrust, and his practice focuses on merger control, civil conduct investigations, corporate counseling, compliance, and civil litigation. Dan is also very active in the ABA Antitrust Law Section, and he is a vice chair for the Unfair Competition Committee, which I think will be quite relevant for our topic today.
Welcome to our Curious Amalgam, Dan.
Thank you. Glad to be here and really excited to talk with you today.
Awesome. So I'm personally a big celebrator of birthdays and anniversaries. And today we are recognizing the 2-year anniversary of the Federal Trade Commission's policy statement regarding the scope of unfair methods of competition under Section 5 of the FTC Act, which we'll call the FTC Section 5 policy statement for short. As most of our listeners know, Section 5 of the FTC Act prohibits unfair methods of competition and authorizes the Commission to take enforcement action to have companies cease and desist from such actions that run afoul of that prohibition. In November of 2022, FTC Chair Lina Khan, joined by Commissioners Slaughter and Bedoya, explained that, quote, in recent decades, the Commission has allowed this Section 5 authority to lay dormant and announced the adoption of a new policy statement in which the Commission would, quote, rededicate themselves to executing the full set of duties Congress tasked us with more than a century ago. And so with that bold pronouncement as context, I will pass the mic over to Sergei and Dan to talk about the history of Section 5 and how we got to where we are today. Sergei?
Thank you, Jeny. And as Jeny said, let's start with the history before we get to the actual policy statement. What has been the historic role of Section 5 in antitrust enforcement before the Biden administration and before the 2022 statement?
The term unfair methods of competition is not defined under Section 5. So the question becomes, does Section 5 cover conduct that goes beyond the Sherman Act and the Clayton Act? In the past, one particular concern with bringing standalone Section 5 claims is that if the agency took too aggressive of an approach, it could backfire and result in a ruling that limits the scope of the agency's Section 5 authority. But in other situations, notably through its administrative process and the use of consent decrees, the Commission could cite its Section 5 authority to articulate its views and get additional concessions from the parties. To that end, the Commission traditionally has relied on Section 5 authority in a limited number of cases. Two are worth mentioning. One is invitations to collude. In this situation, you have a company that signals to its competitor that it wants to price in a certain way, but the competitor does not respond in kind. Under the Sherman Act, there must be an agreement before the agency can bring enforcement action. But under Section 5, even though there's no agreement, these facts could still serve as the basis for a claim. The other scenario involves certain patent-related issues. For example, Section 5 has come up in the context of deception involving standard-setting organizations. It's also come up in certain pharmaceutical transactions where there's a perception that the acquisition will allow the acquiring party to exercise greater market power associated with the patent. The idea then is that the combined entity gains pricing power through the acquisition. The FTC in the past has sought to address such concerns under Section 5.
So it sounds like it did have a use before the 2022 policy statement, but it was somewhat limited. Why did the FTC then decide to change course in 2022?
I should also mention prior to 2021, and this is related to why they issued a new statement, they specifically rescinded what was called the 2015 statement. And that statement had two notable points. The first was that in determining whether they would bring a standalone Section 5 claim, they would
apply a framework similar to the rule of reason. What the rule of reason just means is they're going to do a full economic analysis of the conduct to determine whether it harms competition and whether the company that is undertaking the conduct has some kind of pro-competitive business justification. And then the other factor, second factor that they would evaluate is whether the conduct at issue is already sufficiently addressed under the Clayton Act or the Sherman Act. If you look at the press release for the 2022 statement and the decision in 2021 to rescind the 2015 statement, their view was that the 2015 statement contradicted the text of the FTC Act. And in particular, they were critical of the idea that you should apply a framework similar to the rule of reason because they saw that as limiting the scope of Section 5. In their view, instead, Section 5 expressly reaches beyond the Sherman Act and the Clayton Act, and there's not necessarily this need for full-blown economic analysis. So they saw the 2022 statement as being necessary to restore what they called the full scope of the agency's enforcement authority under Section 5, where you have more of an evolving standard of what constitutes an unfair method of competition. So I'd say there's 4 key points that's in that statement. 1, it makes explicit that unfair methods reach beyond the Sherman Act and the Clayton Act. 2, that the agency is not limited to applying the rule of reason. 3, that it reaches what we would call incipient violation. So that means even if the conduct hasn't actually materialized to having an actual anti-competitive effect or hasn't materialized to being an agreement, that's still something that can be addressed under Section 5. And the 4th point is on what you'd call cognizable business justifications and efficiencies. So there, as an initial point, cast doubt on the idea that a cognizable efficiency can be a defense. But even assuming it could be a defense, that's a burden that's on the defendant, and it has to be pretty detailed proof and evidence to do that. In terms of laying out additional specific cases that the FTC would apply Section 5, it's pretty light on specifics, and which makes sense because the whole idea is they want kind of this evolving standard. But I guess I'll mention 2 notable cases. So one is this idea of what they label parallel exclusionary conduct that caused disaggregated harm. So again, going back to this idea, you need an agreement under the Sherman Act among competitors to bring a claim, and parallel exclusionary conduct would say, okay, you have competitors in an industry that are acting in a similar way. Even if there's not agreement, maybe that's something we should be focused on. And then the second thing is kind of what I would call a monopoly suit theory. So you look at a bunch of individual conduct, whether it's acquisitions or certain kinds of contracts or certain types of business practicing like using leverage in business negotiations. Any of those individual acts might not violate the act, but if you look at them in total and you kind of throw them on the board, then that might be a problem.
So you mentioned 2 specific cases where Section 5 might apply, but it's also broader than that. As you mentioned, it's an evolving standard. It's not limited to these 2 circumstances. And one reaction I've heard to the new Section 5 policy statement is that it does not provide enough guidance on what conduct does or does not violate the law, that it makes it pretty difficult for lawyers to counsel clients or for businesses to have certainty about what's on the right side of the law and what's on the wrong side of the law. Do you think that's a valid criticism or is that misplaced? What's your take on that?
So I do think it's a valid criticism, but it's also a criticism that goes to the heart of the policy debate. So of course, from a business perspective and as someone that advises clients, the key issue is always you want clear rules of the road, you want compliance, you want certainty. But from the enforcement perspective, they would highlight that there's a reason that unfair methods of competition is not defined by the statute. So that ambiguity for them is not really a bug, but it's a key feature of the law. And it confirms that the term unfair methods of competition, something that's supposed to evolve over time to adapt to new circumstances. And it's really broad, and it confirms that it's a broad grant of authority. So, I mean, there is the counter that the agencies have to exercise prosecutorial discretion at the end of the day, and not having clear guidance puts companies in a bind because companies are trying to do their best. And as practitioners, we're trying to advise them best on how to create a culture of compliance. And if they don't know exactly what's prohibited, then they don't have adequate notice to set up that kind of compliance structure within their company. So to that end, I think there's a tension between kind of we know it when we see it approach and wanting to provide legal certainty to the business community. And it's all to say that I think your question speaks more generally to the disagreement about how the agency should be operating and enforcing Section 5 in the first place.
Yeah, I guess there's always going to be that trade-off between certainty and flexibility, and hard to get it just right. Jeny, do you want to jump in here?
Yeah, just to follow on, like a lot of the antitrust laws, the question about what is unlawful or not is developed through case-by-case adjudication. And you need cases and opportunities to explore the law in order to get decisions. Since they have announced this new policy statement and they reinvigorated or broadened scope of Section 5, how has the FTC used that authority to push the law forward?
I would say there's, let's call it 4 buckets of actions the agency has taken to lay out or put into effect the statement. So the first bucket I would call their rulemaking initiatives, particularly on the non-compete rule. The second category is the issuance of additional policy guidance on particular conduct that they view as being covered under Section 5. So that would be, an example would be the Orange Book statement, which deals with listing of patents in the FDA's Orange Book. Third category, I would call on the merger front, in particular, the use of consent decrees, and through their issuance of complaints and entering into those consent decrees, they've laid out how they view Section 5 as applying in the merger context in particular. And then the fourth would be actual litigation, enforcement cases, and that would be litigation both in court and through their own internal administrative process.
Well, let's go through these buckets in a little more detail, and let's start with the first one, the rulemaking. You told us about the non-compete rule passed under Section 5. Could you tell us a little bit more about this rule and how the courts have responded to the rule?
Yes. So the rule came out in April, and essentially it issues what is a categorical ban on the use of non-competes. There is a very narrow exception for the use of non-competes in connection with the bona fide sale of the business, but in all other contexts, essentially, particularly employment, licensing contexts, the use of non-competes would be prohibited under the rule. So that led to a flurry of litigation, 3 separate cases in 3 federal courts, 1 in Pennsylvania, 1 in Texas, and 1 in Florida. There have been decisions in each of those cases, and the FTC lost 2 of the cases and succeeded in the third, but that third case was ultimately voluntarily dismissed by the plaintiffs. So in terms of the reaction of the courts, I would say it's been mixed, but it's leaning towards the negative direction. So just to give a brief overview, so in the Texas case, the court concluded that the agency doesn't have any authority to issue substantive rules at all. The Florida case took more of a middle road approach, and it said that the Section 5 does give the FTC some authority to issue substantive rules, but this substantive rule exceeded that authority. So it used a funny analogy of hiring a babysitter and giving your babysitter the credit card to do something fun with the kids while you're out to dinner, and you come back and it turns out the babysitter is taking your kids on an all-out extravaganza to Las Vegas. So yes, it's clear Congress gave the FTC the credit card, so to speak, to take them out for ice cream, but not necessarily to Las Vegas, which was analogous to the non-compete rule. And then in the third case, in the Pennsylvania case, the court concluded that the FTC does have the authority to issue substantive rules. So right now, the Florida decision and the Texas decisions are on appeal in the 5th and the 11th Circuit, and it remains to be seen how those cases will be decided, although the expectation is that those decisions will likely be upheld.
So what kind of effect do you think the court's negative response to FTC's use of Section 5 authority may have on FTC's ability or willingness to use Section 5 aggressively to, take out the credit card and take the kids out to Vegas, so to speak?
They've definitely been less successful on the rulemaking front, but they have brought cases also that are standalone enforcement cases. So there hasn't been too many opinions that have been issued there, but they have had more success in those individual enforcement cases, which I'm happy to talk about, in particular, their case with Amazon.
Let's do that. Let's talk about the standalone enforcement cases.
So let's start with the Amazon case. So the Amazon case does include a standalone Section 5 claim, which came up on the motion to dismiss. Case focuses in large part on Amazon's discounting practices and their use of algorithms to track online pricing. And I won't necessarily get into the details of all the claims in that case, but just on the standalone Section 5 claim, in simple terms, the FTC alleged that Amazon used an algorithm to monitor whether other companies matched their pricing on previously discounted products. Amazon argued in response that their use of an algorithm to track other pricing and their own unilateral pricing decisions, regardless of what their competitors do, is not something that should be addressed under standalone Section 5, because ultimately there's no agreement being alleged, and how their competitors react is not an antitrust issue. So I think this goes kind of back to the parallel exclusionary conduct we were talking about before. And the court did address this issue. Somewhat cursory. It's a very short analysis. I mean, maybe half a page. But essentially, the court said that it was enough, at least on the motion to dismiss, for the FTC to have alleged that the use of an algorithm, if Amazon had knowledge that other competitors would follow their pricing, that's enough for a standalone Section 5 claim. In my opinion, it's a little hard to read too much into the decision because it was very cursory and it is still a motion to dismiss. And oftentimes when you're talking about very novel legal issues, courts are reluctant to give decisions that are very detailed or definitive without the benefit of discovery. So I would still think this issue will still come up again on summary judgment, and that's probably going to provide a lot more guidance in terms of what courts are thinking in terms of defining the FTC's standalone Section 530.
How about in the administrative realm? The FTC recently brought a case against the largest PBMs in the country under Section 5. Can you tell us a little bit about that case?
Yes. So the PBM case is another interesting example. And there is a consumer protection element of the case also, but I will focus here on Section 5. So the basic claim is focused on how the PBMs design their formularies. Specifically, the FTC alleges that the PBMs tie rebates primarily to the list price of insulin, and that causes PBMs to favor insulin products with a higher list price for which they could give a higher rebate. And that has the effect of excluding lower list price products from the formulary. When you're looking at the allegations, there does kind of seem to be this theme of foreclosure about excluding lower list price products, but it's really a product design and pricing decision type of case. It's really focused on how the formularies are designed and how they're doing the pricing. That seems to be the issue. So it's not a traditional antitrust case because there's no allegations that the PBMs actually agreed with each other horizontally on how to set up their formularies. And none of the defendants individually are alleged to be monopolists. So that's why you don't have the Sherman Act claim attached. So it kind of goes back again to this idea of parallel exclusionary conduct and whether that can be enough of a basis to bring a standalone Section 5 case.
And it seems there's kind of a gap there. We're in Section 1, Section 2. What happens if it's unilateral conduct that you're worried about, but it doesn't quite rise to the level of monopolization or attempted monopolization? Seems like Section 5 is trying to fill that gap. So we've talked about how FTC is using Section 5 in rulemaking and bringing standalone Section 5 claims in litigation. Let's briefly cover the other two buckets that you mentioned, policy guidance and merger enforcement. How has FTC used Section 5 in those contexts?
Starting with the bucket of the issuance of policy guidance. So the main example is the Orange Book statement. So as I mentioned, there is the Orange Book, which is a publication put out by the FDA, which puts generic companies on notice of certain types of patents that a brand company says read onto their product. The FTC put out the statement, and the statement argues that if a company makes an improper listing in the Orange Book, that can itself be an antitrust violation under Section 5, with the idea that those improper listings have the effect of excluding generics and keeping prices high. In terms of enforcement, we haven't actually seen a standalone Section 5 case. We have seen the FTC bring administrative complaints before the FDA. And I would say there would be at least some hurdles for the FTC if they were to bring a standalone Section 5 case in that context. And I'd say in two main ways. One is the idea that petitioning activity, legitimate, good faith petitioning activity before any government agent is viewed as a form of protected speech that's typically immune from antitrust attacks. So a common example is in the litigation context. So when you enforce patents, unless it's what's called a sham, so that means it's completely baseless objectively and subjectively, then that the act of enforcing a patent is protected under the First Amendment and outside the scope of the antitrust laws. So similarly here, if you're talking about improperly listed patents, whether that's enough, if the company had a good faith basis for posting the patent, or whether, even if it was an improper listing, is that really going to be enough to show without evidence, for example, of actual fraud on the FDA? Another challenge, of course, just more generally showing that the listing by itself harmed competition. So you would have to show that one, the generic companies actually cared about the listing and didn't bring the product to market because of that actual action. And the other thing is that even if you're dealing with this product, you have to still have monopoly power with respect to the product. Just having a patent or listing a patent by itself is not considered to give you market power. So you still have to deal with all those issues of market definition and alleging monopoly power. And so
let's dive into the fourth bucket, merger enforcement.
On merger enforcement, I'd say there's two categories where you've seen enforcement. The first would be what are called interlocking director rights, and the second, the conglomerate merger context. So covering interlocks first, there are two cases in particular: Quantum's acquisition of certain assets from a company called EQT and Axinn's acquisition of Pioneer. The idea of an interlock is that someone that serves as a director on one company cannot serve as a director on another company. So that's prohibited under Section 8 of the Clayton Act. It is a per se statute in the sense of if you're serving as a director on both corporation and regardless of competitive effect, that is prohibited under the act. That act, though, only applies to, in certain contexts in particular, the companies have to be corporation and they have to have competitive sales. Those two cases that I mentioned are interesting for two reasons. So in the Quantum EQT case, it was interesting because Quantum was a partnership, so it's not a corporation. Under the consent decree, the company was barred from having any of its partners serve on the board of EQT. So that was an example where Section 5 was used to apply Section 8 principles to non-corporate entities. And then in the Pioneer case, the consent decree not only banned a certain individual from serving on the board of Axinn, but from the person even being nominated to the board. The consent decree didn't even give them an opportunity to resolve the interlock or to address information sharing concerns via other kinds of safeguards, but covered nominations of directors as well. So those were two of the ways that those cases were different. And then on the conglomerate merger context, the most notable example was the Horizon Amgen case. On the Section 5 point, one of the allegations was that Amgen had a history of leveraging its portfolio of drugs to gain advantages in formularies in terms of securing higher prices for the products from insurers. There's no allegation that those historic examples were themselves actual violations of the act. The complaint doesn't say that Amgen had been found to violate the antitrust laws by having used that leverage. So it kind of goes back to what I was talking about earlier with the monopoly soup theory, that even though there might have been examples in the past where they took actions that didn't necessarily violate antitrust law at the time, those actions combined with this acquisition is being argued as having violated Section 5 in addition to Section 7. Ultimately, how receptive court would have been to that kind of claim is unknown, since the parties ultimately settle.
Well, it sounds like FTC has certainly been very busy in applying Section 5 in a variety of contexts. But of course, we have a new incoming administration now. We'll have presumably a new FTC. And what do you foresee for Section 5 policy and enforcement going forward under the second Trump administration?
So if the 2022 statement was the high watermark of Section 5 enforcement, I would expect that to recede with the incoming administration. Would not expect the effort to bring standalone Section 5 cases to have as much traction with the incoming administration for several reasons. One is, just if you recall, when this 2022 statement was issued, it did generate a dissent from the Republican commissioner at the time, Christine Wilson. The Republican commissioners voted against the issuance of the non-compete rule. They weren't involved in some of these consents that were entered into. So it's not clear that even with the current administration, it really had much Republican support to begin with. I think also, if you look at the prior Trump 1 administration, that administration kept the 2015 statement in place. It didn't really do anything to change that. You didn't really see an uptick in standalone Section 5 claims relative to the Obama administration that came before it. And I would say, just more generally from the policy point of view, the past Trump administration and the incoming Trump administration has put a lot of emphasis on not just deregulation, but providing greater regulatory certainty and more efficient process when handling antitrust investigations and looking to mergers. So it's hard to square that with this more evolving view of Section 5 and taking this more of we know when we see it approach. And I think just at also the practical level, that it's taken a lot of resources to pursue these actions, particularly on the non-compete rule. As I mentioned, that's 3 separate litigations. So just in terms of if they would prioritizing, that would make it harder to pursue other priorities that the administration likely has. And if you look at some of the nominees, one of the things that's come up is continued focus on Section 2 enforcement and looking kind of at these novel merger theories. And I think if you're going to pursue Section 5, that could interfere with those priorities.
Well, I think the answer here is continue to watch this space as the new administration gets itself into place. And Dan, thank you very much for sharing your thoughts on the evolution of the law here, but wanted to then transition our conversation to something a little bit more fun, as we do with all of our guests here on our Curious Amalgam. Wanted to ask you a couple of questions about yourself and have a little fun while we do it. So if you could tell us a bit of advice that you would give to an up-and-coming lawyer who is just starting out in practice.
That's a great question. So I'd say 2 main pieces of advice. One is whatever area of law you end up choosing, it just should be something you find genuinely interesting. I mean, I admit about myself that I am a bit of an antitrust nerd, and I was very interested in, how antitrust law developed, and I really love antitrust law in law school. And finding something that you find exciting and that you find interesting really is a big motivation at the end of the day to just help you continue. But I'd say another big point, and maybe even bigger point, is finding the right people. So finding mentors, working with great colleagues, really enjoying that the people that you work with is, I think, so essential. And I think as much as I like antitrust law, the thing that's made me love it even more is the people I've worked with and the mentors I've had. I am really grateful for how they have helped me find opportunities to learn about antitrust, to get involved in the ABA, and get great work.
Excellent. So, as you are a familiar listener to our Curious Amalgam, we like to end our show with a little game that we call the Curious Hat.
And now it's time for the Curious Hat!
The rules of this game couldn't be any easier. I will ask you to pick a number from this imaginary hat, 1 through 10.
8.
All right. Question number 8. What was the most recent movie or TV series that you watched, and what did you think of it?
Well, for me, I have toddlers, so the most recent series I've watched is Storybots on Netflix. It is a very interesting show, actually. I really have enjoyed seeing those episodes with the kids, addressing questions as interesting as what is a budget to why is the sky blue, why we can't have dessert all the time, which is an important lesson for toddlers.
How about what makes something unfair? Can they answer that question?
I will have to raise with them a potential antitrust episode.
Excellent. Well, Dan, thank you very much for joining us this afternoon. And thank you, Sergei, as well. And for all of you listening, we will see you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.